Good morning. This is Seema Sapra, and I'm starting my podcasts today. Even though I need to set up, a space in my where I'm staying so that I have a decent background, but I want to comment upon Justice Suryakant, a statement that he has made on Constitutional Day, where he has said that there is a time, and I'm looking there because I'm reading from my laptop. Time to restore predictability in judicial approach. CJI suggests national judicial policy to avoid divergence across benches. Chief Justice of India Suryakant on Wednesday said predictability in judicial approaches. I'm reading from a live law report. Predictability in judicial approach must be enforced across courts in the country, and avoidable divergence that may arise because there are 25 high courts and multiple benches of the Supreme Court must be avoided. It is high time we minimize unpredictability and avoidable divergence that may arise simply because there are 25 high courts and multiple benches of the Supreme Court. Justice cannot resemble a set of instruments producing harmonious notes in isolation but discordant sounds when played together. Instead, we must strive for a judicial symphony, one rhythm expressed in many voices and languages but guided by a common constitutional score, he said. Now, he suggested that a uniform national judicial policy could be one way to encourage coherence across jurisdictions. The time is also ripe for us to reinforce predictability in our judicial approach. The evolution of a uniform national judicial policy was suggested by him as an institutional framework that encourages coherence across jurisdictions so that courts speak with clarity and consistency. This is what he said. Now, this approach I am suggesting, which has been suggested by Justice Suryakant, I am suggesting this is an incorrect approach. This violates the principle of judicial independence. The Constitution of India already sets out that courts have to function independently and in accordance with the rule of law. They have to apply the law of the land, which is the Constitution, and the laws, other laws besides the Constitution. There can be no external influence, there can be no external institution or policy or guidelines which can interfere with the judicial discretion of that particular judge who is sitting and deciding a case, whether it be a district judge or a Supreme Court judge or a High Court judge. There is already a constitutional mechanism in place, which is the law of precedence, which means that a higher court decisions, including decisions of the Supreme Court and the High Courts, are binding on lower courts. That principle is already there in the Constitution, and it is followed most of the time. Anyway, even in cases where it is not followed, there is always a judicial solution to that. But there can be no external interference with how a judge decides a case. Even Justice Suryakant cannot call up any judge in the country and ask him or tell him, please follow this precedent or please decide the case in this particular way. There can be no external interference with the judicial discretion. And therefore, what Justice Suryakant is suggesting is a mistaken approach. It has a lot of potential for abuse. It has a lot of potential. If it could actually, a certain version of it could actually end up destroying our democracy, destroying our judicial system. And therefore, what he is stating is not a good thing. Thank you.